This is a review for PLA 1003 Fall 2014 Final Exam Review. The entire exam covers a few things from top 10 rules of ethics for paralegals. We'll begin with the introduction. The introduction includes the first few pages of the textbook, the Roman numerals 9 through, looks like 14, 9 through 14 Roman numerals. The terms that we're going to use are included here: legal ethics, they're the same as a professional responsibility, and briefly the American Bar Association, which again is a voluntary association, has guidelines on the proper use of paralegals, and they have, more importantly, in the whole scheme of things, attorney rules that they've created, models from, and some states have adopted them, states such as Florida. What happens is the states codifies them. They make the rules into codes, and the rules they have are the force of law. And the state of Florida, like most others, have adopted the model rules from the ABA. These were called the ABA version of the Model Rules of Professional Conduct. They are not just lawyer rules, they address lawyers, but they also extend these rules to paralegals. They apply to paralegals in many respects. For example, lawyers have to keep client secrets confidential, and so must paralegals, and lawyers have a duty to keep fair timesheets, and so must paralegals. Many other similar rules, there are only a few exceptions, and we'll cover a couple of those as we move through this presentation. Some lawyer rules only apply to lawyers. Lawyers have a duty to supervise their paralegals, and paralegals don't have the same duty. Some lawyers in some states are allowed to accept referral fees, and paralegals are never allowed to accept referral fees. When you're looking for the laws in Florida, remember that the model rules of professional conduct have a numbering system. And what we've done in Florida is we've taken that numbering system and added a 4 followed by a dash. We've added those 4 dash to every rule of the ABA that we've adopted in Florida. So in Florida, the 4 represents Chapter 4 of the rules regulating the Florida Bar. Chapter 4 is the rules of professional conduct. The first rule we're going to cover for this exam review is the Rule 1, have integrity. The rules of ethics are designed to protect the public, and integrity is technically an umbrella duty. It encompasses several rules, and they're difficult to, the integrity rule is sort of difficult to apply to certain of the rules that we're going to cover. So this is sort of an umbrella duty that works out pretty well being handled alone. One of the umbrella integrity rules is that reporting the misconduct of others. The lawyer profession polices itself, and this means lawyers have to report to other lawyers' misconduct. California has a different set of rules. They did not adopt the ABA rules. But if you're referring to the ABA rule, here's an example, Rule 8.3, that says lawyers are required to report the misconduct of others. The duty of integrity does apply to paralegals, though, although there isn't any specific rule requiring that a paralegal report attorney misconduct, because they have no duty to do that. There are 3 different types of regulatory authorities in the U.S. These are all decided by the state that you're in Florida. We have a state bar. It's an agency of the Supreme Court of the state of Florida. In other states, they have other, the first two bullet points here will explain the other types of states. For us, it's the state of Florida being an agency, the Supreme Court having an agency called the State Bar, the Florida Bar. In the book, the author, Deborah Orlik, refers to professional authorities, and professional authorities specifically include, and it depends upon the offense, but an internal and a law office authority, or lawyer disciplinary authority, or the district attorney. So in terms of reporting misconduct of attorneys, these are three options. Definitely, it is not recommended that a person, including a paralegal, report misconduct to the client. There are general rules of misconduct. Those are listed in the textbook, and I've listed them here. Paralegals are still held to the same general misconduct guidelines that you saw on the previous slide. An attorney can't ask the paralegal to do something that the lawyer cannot himself or herself do. So the point of this slide is to explain that. The doctrine of respondeat superior, a Latin term, meaning that let the master answer, is basically what this means, and that generally speaking, the lawyer will be held responsible for the negligence of the paralegal. Now, if something is done outside the course and scope of the paralegal's duties and the attorney doesn't know about it, the lawyer may not be held accountable under those circumstances. And it also makes the lawyer, it looks like I have a duplicate slide here. I'll skip this one. The opposing counsel, oftentimes there are situations where one party's attorney knows about misconduct, and an opposing counsel has a duty to report that misconduct to the proper authorities. However, the threat of reporting misconduct shouldn't be used to gain an advantage in a civil action. And it's also improper to encourage a client to invoke or file some disciplinary accusations against opposing counsel. So if a lawyer has knowledge about it, it should be reported. But basically what we're saying here is it shouldn't be done in order to gain some type of upper hand in a case. Another point made in Rule 1 under integrity is staying competent. And staying competent means that using alcohol or drugs to the point of abuse can lead to problems with incompetence of lawyers and other legal professionals. Lawyer assistance programs are set up in all states, and they are there to provide services to help legal professionals overcome addictions to drugs and alcohol. And it's not really required that lawyers report an addicted lawyer to the disciplinary authority. And the author implies that they usually don't. Typically that's handled differently. As far as other areas that are important to understand about the duty of integrity, Rule 1 is that there are federal laws that discriminate against sexual harassment and from discrimination. Those two are unethical behaviors. The next rule we're covering in the exam is Rule 2 on preserving the confidences and secrets of the client. And there are two parts to this. The first is the duty of confidentiality. The rule says that pretty much you cannot release confidential information. And the author goes on to explain the 3 points to describe what confidential information is. All information is not just facts, it can also be opinions. And the way we receive information is important in thinking about how all information gets to us. The source is does not matter. Whether it's received from the client, other people, or gathered from private or public sources makes no difference. It is confidential information. Some examples from yesterday's newspaper, information on the internet. It doesn't necessarily have to be private information. Even if everyone knows it, it's confidential information. Alright, so it's not all information. As the author points out, it has to relate to the representation of the client. This is an important point. Attorneys will say, in a public statement, for example, that the client was found with a murder weapon, basically relating to a public statement like from the newspaper, whatever. So if a news report says that the client was found with a murder weapon versus the client told the attorney that he or she was found with a murder weapon, the news report is not subject to confidentiality, but the fact that the client said he was found with a murder weapon is in fact confidential. So you see the difference. Even though it comes from all these sources, it's important to recognize that attorneys can comment on what the news says, but the attorney cannot comment on what the client said. The exceptions, remember, in the law office, there are people that need to know, like the staff in the law firm that are working on the case, not other people that aren't working on the case, even if they're employed at the law office. Expert witnesses, of course, are more or less in the need-to-know circle, and the exception of that information can be released, but the attorney will need to make sure that the attorney is consulted with the client about the strengths and benefits of disclosure. And oftentimes we have to do our work, and so for that reason, for example, when answering interrogatories and discovery, even though a client may tell us what needs to be written in an answer to interrogatories, that's confidential. That communication is confidential. But to represent the client, we have to answer the interrogatories. Other exceptions are listed here. What is not an exception is your mother, your father, your sister, your brother, your spouse, your friend, blah, blah, blah. All these folks listed here are not exceptions to the rule. The duty of confidentiality lasts forever. It doesn't end when the representation ends. It keeps going even after the client dies, even if you quit, even when you retire. The duty applies to everyone in the law office, including paralegals. Experts and consultants hired are also subject to the duty. The second part of this rule concerns attorney-client and work product privileges. An privilege is an evidentiary privilege. It's a right given to people. It's a statute. It says that it applies to evidence used in a client matter. So it differs from confidentiality in that it applies to evidence. It's an evidentiary privilege that only applies at evidence, and it can be tangible, like a letter or whatever, or it can be intangible, like a heard conversation. There are two types of privilege that we discuss in this part 2, attorney-client privilege and work product privilege. It applies to evidence when we're under oath. So, in other words, we can't be asked to testify against our own client. It applies all the time, every day, and lasts forever. And again, it only applies when you're in a situation under oath. Applications of it: it applies to communications between attorney and client when the purpose of the communication is to obtain legal advice in anticipation of litigation. And again, it's an evidentiary privilege, usually a statutory law. In Florida, it is a statutory law, and it permits a person to object to the introduction of certain evidence. An important distinction to understand, it's covered in the textbook as well, is the situation between confidentiality and attorney-client privilege. As you know, the news always says what it says. For example, in this case, a client was found with a murder weapon is what the news report says, and the client has told the attorney that you work for, or told you that the client was found with a murder weapon. The discussion, the communication from the client is confidential information. The news report isn't a confidential or a privileged situation, but the client telling you or your attorney that he was found with a murder weapon is confidential. So you can't tell another person that the client told you this. However, it's not privileged information because telling your friend or another person, if you should do such a thing, is not a situation where you would be under oath. The attorney-client privilege is owned by the client, and the privilege is held by the lawyer, for the work product, that is. The attorney-client privilege by the client, the work product is a privilege held by the lawyer. Why is this important? To keep the communication between the attorney and the client from being disclosed. And the client needs to be comfortable telling the truth. It covers oral and written communications from between the attorney or paralegal and the client, and communications created for the purpose of obtaining legal advice. Work product privilege is about work product. So if an attorney writes a memorandum about the case, an opinion or something, that is the stuff that we're creating on the job in anticipation of litigation. It includes legal and factual memorandums, etc. Those are work products as opposed to attorney-client communications. We have to be careful about inadvertent disclosure of work product. They can accidentally be faxed or emailed or whatever to the other side. So it's important to exercise real caution when using technology in emailing or faxing documents here and there to make sure they don't go to the wrong place. There are some exceptions to the work product privilege. Sometimes people will, in litigation, make the argument that there's a substantial need and undue hardship would be had as far as the case is concerned if the work product is not admitted into the courts. You know, a couple of little points here that are interesting, not necessarily important for the exam. You have to take reasonable steps to maintain the secret nature of it, or the privilege may be lost. The fourth, rule number 4 is the next rule to cover in this exam. This is about charging only fair fees, and it also covers client trust account, which isn't very well stated in the title to this Rule 4, so I went ahead and included it here. All right. Agreements with clients should always be in writing. Tell the expectations, explicitly explain the costs, and they have to be explained to the client as well. They have to be signed by both parties, and the client must be given a copy. Unauthorized practice of law and the fee agreement is important to understand. A paralegal cannot negotiate fee agreements. That would require giving a legal opinion. The fee agreement must be explained to the client. And the paralegal can, without committing an authorized practice of law, explain the contract to the client. But care should be given not to give a legal opinion in doing so. There are different types of fee agreements. There is a contingency fee agreement, and that is the type of fee agreement that's calculated based on a percent or settlement of the award. There's an hourly fee agreement, and that's based on the hours spent on the case. There's a value fee types of fee agreements where there's a fixed or flat fee agreement, and is often used for repetitive types of work. A fixed fee agreement would be one with a set charge for a specific type of service. Contingency fee agreements are where lawyers get paid fees only if there is a positive outcome that generates money for the client. Remembering to keep understand the difference between fees and costs. Costs must be paid by the client regardless of the outcome, and each state has different laws regarding this type of situation as far as costs. In some states, the client may not, the lawyer may not be able to be permitted to get the costs back from the client. And these are typical in plaintiff's personal injury work. They're not permitted for public policy reasons in areas like criminal defense and marital dissolution. Hourly fee agreements, they spend time, lawyers and paralegals work on the case. We call this kind of work billable work, and the client gets a bill when they do the tasks on behalf of the client. Each lawyer and the paralegal is assigned a billing rate. It can be 100 to 1,000, for example, a lot less for paralegals. These fee is based on the hours spent on the case. This is the most widely used form of fees in cases such as divorce, marital dissolution, criminal defense, personal injury, defense, not personal injury, prosecution of a personal injury, but defense of it, and business litigation. They're keeping track of billable time. Used for personal injury. The ethical requirement is that time records should always be honest. Personal injury defense. Time records should be thorough and describe the task. Keep track of time contemporaneously with the task so that you're not forgetting to accurately write it down. And it must be accurate, and it must. Those are the main points: honesty, thorough, contemporaneous, and accurate. We usually bill time in 1/10 of an hour increments, and those are 6-minute increments. What is billable work? Billable means that they're charged at a billable paralegal rates regardless of who does the task. Or paralegal, I should say, even if lawyers do the task, they would have to be charged at a billable rate commensurate to the task. So, a lawyer can't do the job and expect to pay a ethical fees, lawyer padding fees your time sheets. That's when you write down and record your time, your billable time is inflating your time, and you cannot do that. Overbilling would be the result, and that is fraud, and it's a tort and a crime. Retainers is the other subject on the exam. A security retainer works like a deposit. It stays in an account and it ensures the client pays the lawyer bills. Law firms will bill against the retainer. They take the money from the retainer amount to pay the bills. Non-refundable retainers are also possible, which means these monies are not billed against, but the money is earned on receipt. Types of advanced payment retainer is like non-refundable retainers and advanced payment retainers. To expand the list, We have security retainers. Security retainers are paid to secure payment for future services. They're not earned until the work is performed. Classic retainers are earned upon receipt. So when we hear the term that's a classic retainer, it's earned upon receipt. A non-refundable, it's earned upon receipt regardless of the work performed. Trust accounts are often called advanced payment retainer. It's earned upon receipt but paid to the attorney in advance for performing the work. Retainers, those not earned on receipt, must be deposited into the attorney trust account. Classic retainers, as noted earlier, those are the type that are earned upon receipt. They can go directly into the general operating account, and they're earned after the client earns the money. In other words, once the work is performed, the attorney sends a bill to the client. As long as the client doesn't object to the bill, the money is earned. That's your classic retainer. The money is there. It may be earned in all technical sense by the lawyer, but the lawyer shouldn't spend the money until the money for like rent or paying bills until the purpose of a trust account sent to the client. It's a deposit account. It holds retainers. It holds settlement money from cases. It holds judgment money. It holds escrowed funds, like when there's a real estate sale. The general operating account is a regular business account. It is used to pay office expenses like rent, salaries, overhead items. Money in the general operating account is earned money, and it can be earned money that was placed into the general operating account directly, or it can be money from the trust account that it was removed upon the trust account and deposited there once it was earned. Where the money goes when it comes in the office, you need to make sure that it goes into the lawyer trust account or the general operating account. Or maybe it goes into the lawyer personal account. I don't know. That is possible, but usually it's moved in the form of salary. Never ever deposit trust funds, that kind of money that's on retainer of some kind, in an operating account, unless you're told to do so because the attorney has maybe accepted a classic retainer fee or something like that. One of those that's already earned. Account violations. Lawyers are often disciplined for having the wrong money in the trust account. There can be multiple trust accounts in a law office, and not depositing them into the correct account is a big danger. Fee fights happen sometimes. Only lawyers and clients disagree about the trust account, not personal funds of client files. The next rule we're going to cover cannot be held hostage for unpaid client fees. Don't practice law without a license. Remember, the definition of the practice of law is applying a rule to certain person's facts and giving them a response. Recognizing the unauthorized practice of law by looking at these 3 points to help you break it down into elements. The traditional categories of UPL: going to court, giving legal advice, creating legal documents without attorney supervision. Remember that the attorney reviews the documents, ensures that they are correct, and signs it, adopting it as his own. Traditional exceptions, though, to UPL, unauthorized practice of law, are listed here. Don't forget the incidental rule. Sometimes a trust officer or a CPA, they have to do it They have to practice law to do their job, so it's incidental to their jobs. The typical scenario of a challenge for paralegal is when the client calls with a question and you know the answer. And this happens almost all the time when you've gotten used to the work and what the typical answers are. But even if you know the answer, you can't give the answer. Just don't give legal advice. Always rely on the conduit theory. Also recognize the distinction between unauthorized practice of law and an opinion. The example improper of business relations can give the appearance of she knows you're going to paralegal school. So now if you answer partnership or an ownership interest in relying on your legal knowledge, and that can lead to her bridge partner asks her the same question, she's not relying on that. Non-lawyers cannot have an ownership interest in a law firm. Lawyers get us in trouble, paralegals in trouble when they don't supervise, delegate inappropriate tasks, enter into improper relationships with paralegals, business relationships, or divide fees or pay them referral fees.